Hello, good evening, Priyanshu. Dr. Mary Sport, welcome.
Good
Am I
evening, sir.
audible?
Yes, you are
Mm.
audible. Am I audible?
Yes. So good evening, participant. Thank you very much for joining. We'll be starting soon. We are waiting for our guest to join.
Kalpesh sir, my video and audio is audible, right? I think it's lagging.
Yes, yes, yes.
Yes,
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 it's audible.
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 Good evening, everyone. Good evening, Vijay Kumar ji, Vinita Pradhan ji, Mamta ji, Dr. Ruby Chatwal ji. Good evening, everyone.
Kalpesh sir, who is today? Sachin sir, right? Kalpesh
Yes,
sir?
Sanjay sir.
Sanjay Jain sir. Uh,
Yeah, I have
okay.
reminded him.
Uh,
Maybe
Message or call?
I have messaged him. Yesterday I messaged him Paul also. So joined 7 or 2 p.m. like yesterday. So I've just reminded, sir. Otherwise, I'll call in couple of minutes.
No, generally, okay, you just call
Yeah,
him.
I'm just sorry. Yeah.
Dear participants, our guests will be joining in a few minutes. Thank you so much for your cooperation and patience.
Hello. Hello.
Yes, sir. Sanjay sir, welcome, sir. Good evening, sir.
Yeah, good evening.
So, shall we start, sir? For permission.
Yeah.
Okay. Over to you, Jain, sir.
Good evening, Sanjay Jain sir. This is Maris here.
Good evening. Good evening.
Good evening.
Morris.
Yes, sir.
Good evening, everyone. I, Priyanshu Saxena, Assistant Professor for Mewar Law Institute, welcome you all to the fifth day of the 10-day online capacity building program on disability laws. Undoubtedly, this is a remarkable program, which is being jointly organized by Pro Bono India and GNLU Center for Disabilities Studies, Gujarat National Law University, Gandhinagar. And it is actually my privilege to introduce our distinguished speaker for today's evening, Dr. Sanjay Shrikant Jain from National Law School of India, University, Bangalore. Dr. Jain brings 25 years of exceptional teaching experience and holds a PhD in law with specialization in constitutional and administrative law. And what makes him truly remarkable is that his scholarship has been cited by Justice D.Y. Chandrachud in landmark Supreme Court judgments, including Vikas Kumar case, establishing disability rights in civil services. As someone who self identifies as totally blind since birth, Dr. Jain received the National Award in 2004 from President Dr. APJ Abdul Kalam sir for his outstanding contribution to disability advocacy. He is the author of Critical Essay on Disability Rights, Jurisprudence, and brings both lived experience and academic excellence to legal education. Today, Dr. Jain will share his insights on Rights of Persons with Disabilities Act 2016, duties and responsive public engagement and grievance redressal mechanism. So, ladies and gentlemen, please join me in welcoming Dr. Sanjay Jain. Thank you, Dr. Jain, and please go ahead.
Yeah. So thank you very much for this very kind introduction. Today, the topic which is assigned to me is duties and responsibilities of appropriate government. Now, it is a very vast topic.
7:09 p.m. One notification. Cars 24. 7:09 p.m.
Because
Access voiceover off.
it was almost every section of RPWD Act refers to the duties and responsibilities of appropriate government. But the context which is to be used by me is the grievance redressal mechanism under the RPWD Act. So, and then I will use examples from some other sections of the Act also. Yesterday I covered largely the skill vocational training, skill development, self-employment, vocational training, and employment, and education. So maybe we'll get the other provisions in relation to the duties and responsibilities of the appropriate government. Now, before we go into the term appropriate government, It is important to note that this law is a central law and it is enacted by the Parliament in order to ratify United Nations Convention on Rights of Persons with Disability. So, if you read the preamble of the law, the following Act of Parliament received the assent of the President on so and so. The Rights of Persons with Disability Act 2016 and it's enacted on 27th December 2016. Now this act enacts to give effect to the United Nations Convention on the Rights of Persons with Disabilities and for matters connected therewith or incidental thereto. Whereas the United Nations General Assembly adopted its Convention on the Rights of Persons with Disabilities on the 13th day of December 2006, and whereas the aforesaid convention lays down the following principles for empowerment of persons with disabilities. So, what are those principles? Respect for inherent dignity, individual autonomy, including the freedom to make one's own choices, and independence of persons, and then non-discrimination, then full and effective participation and inclusion in society, then respect for difference and acceptance of persons with disabilities as part of human diversity and humanity, then equality of opportunity, then accessibility, then equality between men and women, respect for the evolving capacities of disabilities of children with disabilities, and respect for the right of children with disabilities to preserve their identities, and whereas India is a signatory to the said convention, and whereas India ratified the said convention on 1st day of October 2007, and whereas it is considered necessary to implement the convention said, be it enacted by Parliament in the 16th year of the Republic of India as follows. So, this is the preamble, and this preamble goes to show why this law is enacted, and I have already told you that India ratified UNCRPD, and in order to perform its duty, because once you ratify an international duty, then it becomes the duty of the state party, every state party, to incorporate the obligations incurred under such a treaty into its municipal law. And in India, we have Article 253, which empowers the parliament to incorporate treaty obligations into municipal law by enacting legislation. And therefore, under 253, the power was exercised by parliament and this particular law was enacted. And why this law was enacted? To afford the principles, fundamental principles underlying the United Nations Conventions of Right, Convention on the Rights of Persons with Disability, and to also abide by the provisions of this convention or the spirit underlying the provisions of these conventions. Therefore, question arises then, why appropriate government? If this law is enacted by the central government, then why we are using the terminology of appropriate government? Why not central government? So, can anybody amongst the participants throw light on this question? Why appropriate government? Why not central government? Anybody would like to respond? Yeah.
Yes, participant, please raise your hand or put the response in the chat box.
Yeah. Any participants?
Yes, Migma Doma.
Is there anybody who would like to
Yes, sir.
respond?
Sir, I'm unmuting one participant. Migma Doma.
Okay. Yeah. Yeah. Please go ahead.
Yes, Migma, are you there? Yes, sir, one participant has responded as per the convenience of the government.
Okay. As per the convenience of the government.
Of the government, yes.
No, that's not the correct explanation. Any other response? So, friends, it's very important to take note of the terminology of appropriate government. Why we are using the term appropriate government and not central government, even though the law is enacted by the central government. The principal reason for the same is that whenever a law is enacted in India by parliament, can parliament alone implement the law? Because India is such a big country, such a vast country. So can parliament alone, without the cooperation of the state governments, without the cooperation of the local and self-government, say municipalities, municipal corporations, can really government of India, can it implement any law? So answer is clearly no, it is impossible, simply practically not feasible for parliament to extend its writ throughout India to the total exclusion of the other players in the government, particularly the state governments and the third tier of the government, the local and self-government. Therefore, if you would look at some interesting provisions in the Constitution, particularly Articles 255 to 257, you would find the sum and substance of this, although these provisions apply to different domains, but the sum and substance of these provisions is that although the law is enacted by the central government may authorize the state government to exercise executive power and implement the law within its territory. So, although the legislation is enacted by the center, it is subject to its implementation in a particular state is subject to the exercise of the executive power by that state. Similarly, it is also possible that the central government may also impose certain duties and give certain powers under the central law to the officials of the state government, because in each state we need officials for implementing the law. For example, collector, we need collector to be sensitive, collector to be cognizant of the various rights of persons with disability act, and therefore although collector is the part of the state administration, she is the part of the district administration. Yet the parliament, while making law, may resort to his authority, may vest some authority in him, or may also impose certain obligations on him. Similarly, it is also possible to note that the municipal corporations and municipalities, because municipal corporation and municipalities are responsible for public health, sanitation, and other day-to-day needs of the life. Therefore, even such institutions, they are also obligated by the state government. In fact, one of the entries in Schedule 11 and 12 of Constitution of India is persons with disabilities and handicapped, right? Or person with disability and intellectual disability. So it's a very unfortunate terminology. Terminology is not brought in line with the mandate of the NCRPD. But for the timing, if we ignore terminology, it becomes clear that the law, law has a dominoes effect, and it is transmitted right till the end. So the law does not have a top-down approach; it has a bottom-up approach to an extent. Because yesterday I showed you and demonstrated how the law suffers from top-down approach. Most of the things are done from Delhi. But if you look at the spirit of the law, because it is not possible for the central government to do everything, and therefore, and moreover, you need to mold the principles underlying law to the local situation. Situation in Gujarat may be different from the situation in Maharashtra or Karnataka. And Yogita, Darwaza, and therefore you need to tailor the provisions of law. You need to be sensitive to the scenario of a given place when a law is enacted. Now, if you look at the constitutional framework, basically the power to enact law on the subject matter related to disability is vested with whom? It is vested with the state government. Entry 8 talks about the disabled. Somebody has bare act of the Constitution. Can somebody read entry 8 from list 2 of the 7th schedule, state list? Hello. Entry 8, list 2. If somebody can. So whether somebody is looking at the list?
Yes, sir. Yes, sir.
Yeah.
Yes.
Yeah.
So list 2.
List 2, entry 8 in the 7th schedule.
Intoxication liquors, that is sir, manufacturing, possession, transfer, purchase, and sale of
No, state
intoxication
list.
liquors.
It's not
Okay.
concurrent
So
list.
it's a 9, sir. Sir, it's entry number 9, relief of the disabled and unemployable.
Entry number 9, relief of the.
Yes, sir.
Can you
Disabled
read that?
and unemployable.
So relief of the disabled and unemployable, and it's talking about relief as if disabled people are victims, they are vulnerable, they are weak, they are weak, they are not part of the mainstream. Now, if you read entry 8, sir, please read entry 8. What is entry 8?
Entry 8 is intoxicating liquors, that is to say the production, manufacturing, and
Intoxicating
possession.
liquors. And if you can read entry 10,
Burials and burial grounds, cremation,
right? So
cremation
you will
grounds.
see that disability is sandwiched between intoxicating liquors and burial grounds. So what a travesty. And disability is clearly uh, associated with relief. So, okay, disabled people are vulnerable, weak, uh, inefficient. They are like unemployable, unemployed, unproductive, right? So this is entry 8, and it is very awkwardly sandwiched between entry 8, intoxicating liquor, and entry 10, burial ground. Now, if I were to ask you to read Article 41 of the Constitution, Directive Principles of State Policy, Article 41. Article 41, sir.
Yes, sir. Sir. Right to work, to education
Yeah,
and public assistance, certain cases.
yes.
The state shall, within the limits of its economic capacity and development, make effective provision for securing the right to work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement, and in other
So, old age,
cases of.
sickness, unemployment, and disablement. Again,
Yes, sir.
disabled people are identified with very weak and vulnerable class, and right to education and employment is there, but it is subject to economic capacity and development of the state, right? So, why I ask you to see these provisions to demonstrate that under our constitution, a very abysmal picture is painted for the disabled, right? Extremely uh, abysmal picture. Disabled people are perceived as weak and vulnerable. And in order to emancipate the people with disabilities uh, and to um, and to and to uplift them, to elevate their status, and to recognize them as equal citizens, that this particular convention was adopted by the United Nations, and India, by ratifying this convention, committed, gave its categorical, unconditional commitment to abide by the provisions of this act. And naturally, in order to implement the provisions of the convention as mandated in our constitution, a law was enacted, and by enacting law, uh, the administration of law was carefully divided by the parliament between itself and the states and the local self governments. Therefore, when we talk about appropriate government, we talk about a particular authority which is envisaged by a particular provision for the implementation of, for its implementation. So For example, we'll take examples. So what is the definition of appropriate government, first of all? So section 2 clause B, appropriate government means in relation to the central government or establishment wholly or substantially financed by that government or a cantonment board constituted under the Cantonment Act 2006, the central government. So central government means Cantonment Board under the Cantonment Board Act 2006. All the establishments which are wholly or partly financed by such a government. And of course, it also includes all the government departments because we are using the term central government. In relation to a state government or any establishment wholly or substantially financed by that government or any local authority other than cantonment board, the state government, right? So naturally, cantonment boards are already covered under the central government. Therefore, state government would include all the authorities, establishment bodies which are partly or wholly financed by that government, and it would also include all the government departments. So now it is very clear that establishment and departments will be covered by this particular definition. Now, establishment. What is the establishment? What do we mean by establishment? Establishment includes a government established, a government established, a government establishment and a private establishment, right? So, and government establishment means a corporation established by or under a central act or state act or an authority or a body owned or controlled or aided by the government or a local authority or a government company as defined in section so and so of Companies Act, right? Then so therefore it is very clear that when we are talking about establishment, we are basically talking about not the private establishment but the government establishment. So having seen the definition of the appropriate government, and I've already explained you what appropriate government means, let me compare the notion of appropriate government with the state under Article 12. Because definition of state under Article 12 is almost similar to the definition of appropriate government under RPWD. It includes central government, state, it includes legislature at the union level, parliament, state legislature, central executive, state executive, and local and other authorities under in India and under the control of the government of India. So any authority or any other authority or local authority having been under the control of government and the executive and the legislature, they are part of the state. And here, of course, appropriate government would mean the government department and the bodies established by the government. And we have already seen the definition of the establishment. If it is a law which recognizes rights, if this is a law which enact rights or in for the persons with disabilities, then why we need appropriate government? Generally, when rights are vested, rights are to be enjoyed, exercised by a person individually without any interference by the state. In fact, rights are the limitations on the powers of the state. Rights impose obligation not to interfere with the affairs of the people in respect of the domains regarding which the rights are vested. For example, if there is a right of freedom of expression, then a state is supposed to leave the individuals, citizens to their choice, and it cannot say that, okay, I will help you to exercise this particular right. So then why we need appropriate government? Clearly, the rights guaranteed by RPWD Act are different from the rights which we observe in Part 3 of the Constitution, the fundamental rights. They are negative rights mostly. But when we talk about Persons with Disability Act, we are talking about social rights. We are talking about programmatic rights. So rights, the programmatic rights would mean the enjoyment of the rights be contingent on the schemes and programs and the machinery. In other words, rights for the persons with disability would be empty shells without also creation of rights enabling conditions. So, for example, if the law recognizes accessibility as an interest of the person with disability, then for recognition and protection of this interest, the first government has to create rights enabling condition. Now, why rights enabling? Do we need to create any special conditions for exercise of freedom of speech and expression? The answer is clearly no, because freedom of speech and expression is a very natural, normal kind of a right, very basic right. What the state is required to do in order to allow people to exercise this right is merely that, okay, it would not interfere, it would not unduly meddle, poke its nose in the affairs of the citizens. But on the other hand, let's talk about women and children with disabilities, the section 4 of rights of persons with disability, how the act is couched, how this particular section is couched. The appropriate government and the local authorities shall take measures to ensure that the women and children with disabilities enjoy their rights equally with others. When you read this particular provision, section 4, what is the impression? The first impression. The first impression is one may feel very strange. Okay, what the law is saying, the appropriate government and the local authorities shall take measures to ensure that the women and children with disabilities to enjoy their rights equally with others. So, why I cannot directly exercise my rights as persons with disability? Why I need the support of the state? Why, for example, the appropriate government and the local authorities are required to take measures to enable me to exercise my rights as person with disability? The simple answer to this question is, by default, the design of the society, the design of the state is ableist. It is tilted in favor of the able-bodied. And if you want to transform the society, transform the household, subject to regulation of whose the person with disability can stay at homes. Now it is very clear that now it is very now it is very clear that such the now these measures are kind of rights enabling conditions. Without such measures, people with disabilities cannot exercise their rights. For example, if the government does not constitute a committee at the district level for recognition and protection of the rights of persons with disability and to enable them to be the part of the mainstream, the law would look like a paper tiger. So similarly, Section 4, the appropriate government and the local authorities shall take measures to ensure that the women or women with disabilities enjoy their rights equally with others. So what obligation is on the appropriate government? Provide equal protection of law to the women and children with disabilities and ensure that they are able to exercise their full legal capacity as human beings. They are not second class citizens. So this is example of Section 4. Then Section 5, the sorry. Now next section, which is a very good example, is the protection from cruelty and inhuman treatment. So here again, the appropriate government shall take measures to protect persons with disabilities from being subjected to torture, cruel, inhuman, and degrading treatment. And B, no person with disability shall be a subject of any research without his or her free and informed consent obtained through accessible modes, means, and formats of communication, and prior permission of a committee and research on disability constituted in the prescribed manner, and the purpose to the appropriate government in which no less than half of members shall themselves be persons with disabilities or committee members of the registered organization as defined under clause Z of section 2. So it is very clear. Now I will read this again. This is a very interesting clause. Prior permission of a committee for research. Sorry. Yeah, just a minute. Yeah. Prior permission of a committee for research on disability constituted in the prescribed manner for the purpose by the appropriate government in which not less than half of the members shall themselves be either person with disabilities or members of registered organization working for persons with disability. So clearly, if you want to use people with disabilities as guinea pigs, if you want them to be the part of any medical trial, provision demands that not less than half of there should be a committee and to advise the government, and this committee, which is known as research committee, must at least have half of its member as person with disability. And they should take the call whether or not the people with disability can be used as guinea pigs. Now again, do we have any research committee? Have we heard about any such research committee? During the COVID, did you hear of the role of research committee? In fact, that was the most appropriate time for the test for the ability of the so-called research committee. So again, it is a paper tiger. There may be some research committee for the namesake, but this committee is clearly this committee is clearly an empty shell because it does not seems to have any serious impact on the administration of the state government, right? So therefore, it is important that when a right is recognized by the central government, and when central government transmits the information of the access and recognition of a particular right of persons with disability, you may cause surprise. You may give surprise. The state may be catch by surprise because the state may not have prepared on those directions. So therefore, it is important that not only all the teachers of a particular division, but the entire law course, in whichever class there is a new syllabus, they should properly they should ensure coordination, right? So therefore, it is very clear that appropriate government is required because everything cannot be done by the central government. So this protection from abuse of violence and exploitation, this section or the section 6, which talks about protection from cruel, protection from cruel, degrading, and inhuman treatment. So these two sections impose very monumental duties on the state governments. Now, clearly, you must clearly take note of the fact that these duties are not the correlative duties. That is to say, you can't say because the government is under duty, the disabled persons are under right. They have the right. It's not the case. So we are here not using the duty in terms of profile. So that point has to be kept in mind by the participants. Don't confuse mere protest by member. That does not amount to any action against the member. 1 or 2 protests may go condoned. So similarly, it is important that there may be some 1 or 2 lapses on part of the appropriate government, but that does not mean we'll just write off the appropriate government. Now, why appropriate government? Again, I have given you the article, but again, to simplify further the point, why we need appropriate government? Why not the central government? So, central government, when it implements social welfare legislation like Rights of Persons with Disability Act, so for implementation of this law, you need resources, you need money, you need to create infrastructure, you need to eliminate certain infrastructure. So both processes begin simultaneously. And it's not like any other building or any other construction work. The organization which is supposed to be established as an observer by the government in case of any exigency, then it is important that that organization takes into account the rights of persons with disabilities. It bears in mind the provisions of the RPWD Act. So, appropriate government is required to provide impetus to the rights, resources, schemes, and programs announced by the central government and the state governments for rehabilitation of persons with disabilities. Right? Yogita, like glass pani देते एक glass pani. So, friends, therefore it is very clear that the role of appropriate government would vary depending upon the right or obligation it is required to enforce. It is required to create a program, right? So let me now illustrate. I have now till now I was reading certain provisions which talks about mere obligations, duties to create conditions, but there sometimes the government's role, appropriate government's role, is bigger than merely recognizing the right. So let me give you the example. Now, access to justice is an excellent example. Section 12, the appropriate government shall ensure that persons with disabilities are able to exercise the right to access any court, tribunal, authority, commission, or any other body having judicial or quasi-judicial or investigative powers without discrimination on the basis of disability. The next clause, the appropriate government shall take, and this is very important, take steps to put in place suitable support measures for persons with disabilities, especially those living outside family and those disabled requiring high support for exercising legal rights. So you need to take, for example, measures, particularly for two types of the disabled people: those who are outside the family or those who need high support. So this kind of duty, and this is not merely the duty, this is also the responsibility. This is power coupled with duty, power coupled with duties and responsibilities. And what measures the appropriate government should take? Now, it is a very general provision, it's a generic provision, it's a framework provision, framework section. So this framework section has to be crystallized into concrete obligations by the appropriate government by developing programs, schemes, schemes. So therefore, such duties are also known as the programmatic duties. Next, the National Legal Services Authority and the State Legal Services authorities constituted under Legal Services Authorities Act 1987 shall make provisions including reasonable accommodation to ensure that persons with disabilities have access to any scheme, program, facility, or service offered by them equally with others. So, facilities, services, programs, and schemes made by the government from time to time, if you want them to be availed by persons with disability equally with others, then again you have to take suitable measures. Again, this is a very generic obligation which has to be concretized by the Legal Services Authority, and both under the central level and the state level. The appropriate government shall take steps to ensure that all their public documents are in accessible formats. Now, this is another programmatic duty. You can't just perform this duty without proper planning. Ensure that the filing departments, registry, or any other office of records are supplied with necessary documents and evidence in accessible formats, and make available all necessary facilities and equipments to facilitate recording of testimonials, arguments, recording testimonies given by the accused or witnesses, arguments or opinion given by persons with disabilities in their preferred language and means of communication. So therefore, it is a very important provision. Then legal capacity, section 30. The appropriate government shall ensure that the persons with disabilities have right equally with others to own or inherit property, movable or immovable, control their financial affairs, and have access to bank loans, mortgages, and other forms of financial credits. The appropriate government shall ensure that the person with disabilities enjoy legal capacity or on an equal basis with others in all aspects of life, and have the right to equal recognition everywhere as any other person before the law. So I should have equal capacity in financial domain, banking, ability to create mortgage. I must be able to inherit property. For all this, because by default, the law is discriminatory. The law and the social norms are such by default that they do not recognize people with disabilities as equal citizens. Therefore, this special duty on the appropriate government. When a conflict of interest arises between a person providing support and a person with disability in a particular financial property or other economic transaction, then such supporting person shall abstain from providing support to the person with disabilities in any given transaction. So, if I am relying on you for support. But if in any particular financial transactions, if my interest and your interest are conflicting, there is a conflict. In such case, the supporter, person who is providing support, must step aside. He should not interfere, right? So these are some of the examples of legal, the appropriate government's duties and responsibilities. Now, let's talk about grievance redressal. And this is a section which I had briefly alluded to yesterday. This is section 23 of Sanskrit Assembly. Appropriate government every government establishment, and government establishment is also appropriate government. Therefore, every government establishment shall appoint a grievance redressal officer for the purpose of section 19. Now, what is section 19? It is important. Section 19 talks about vocational training and self-employment. So, don't you think that it is such a ridiculous provision? Why the law must confine the role of grievance redressal officer to the matters mentioned in section 19? It's anybody's guess, anybody's speculation. It's a very unfortunate provision. Every establishment shall register shall register a copy of the said policy. Sorry. Yeah. Clause B is any person aggrieved with the non-compliance of the provisions of section 20. Now, this is very interesting. Now, let us read this again. Every government establishment shall appoint a grievance redressal officer for the purpose of section 19. For the purpose of section 19, and shall inform the chief commissioner or the state commissioner, as the case may be. This is so far so good. And I don't know why only section 19 is referred, but the next section is even more curious. Any person aggrieved with the non-discrimination compliance, any person aggrieved with the non-compliance of the provisions of section 20, and after 20 there is a comma, 20, I don't know, because 20 may file a complaint with the grievance redressal officer, who shall investigate it and shall take up the matter with the establishment for corrective action. Now, on one hand, in clause 1 of section 21, right? Section 23, sorry. Section 23, clause 1 says that grievance redressal officer is for the purposes of section 19, whereas clause 2 says that if section 20 is not complied with by any establishment, then he can, and if the officer receives complaint, then he can take cognizance and he can take up the matter with the establishment. The grievance redressal officer shall maintain a register of complaints in the manner as may be prescribed by the central government, and every complaint shall be inquired within 2 weeks of its registration. Right? If the aggrieved person is not satisfied with the action taken on his or her complaint, he or she may approach the direct the district level committee on disability. So the appellate authority against the decision of the grievance authority is district level committee. But do we have district level committee? We don't. And what is unfortunate again is that the grievance redressal forum, grievance redressal mechanism appears to be for the purposes of section 19 and 20. Initially, it carries the impression that it's for 19, but uh, uh, but when you read clause B of section 23, it becomes clear that it is also applicable to section 20. So we have to ask ourselves whether grievance redressal is required only for the purpose of employment. Why we do not have any provision for the appointment of, or do we have any provisions for the appointment of grievance redressal officers so far as educational institutions are concerned? Do we have any such provisions? Now, the sections which we should look at is section 17 and section 16. And 16 and 17, if you read carefully, you don't find any provision for grievance redressal. So why?
Sanjay sir, sorry to interrupt, but
Yeah.
it's we are running short time. It's
Yeah,
20. It's 8:08 now.
Yeah.
Yeah,
So
so
let me
kindly.
finish. Yeah. So
Okay, sir.
let me
Okay,
finish. So why then we have, why the law doesn't envisage grievance redressal in respect of the other aspects of the law, right? Why grievance redressal should be confined only to the skill development, self-employment, and public employment, right? So on the note on which I finished yesterday, on surface, the law looks beautiful. On surface, we have the impression that this law has carried forward the commitments made by India to the United Nations. But when you subject the law to the scrutiny, when you subject the law to the analysis, when you look the law through the lens of an internal observer, like person with disability, person with disabilities, person like me, who is a real beneficiary of this law and who is also the victim of this law, then we realize the follies of the legislation. So I would end by quoting Solomon. Solomon used to memorably state that it is not necessary that law always brings with it uh, solace or remedies. Sometimes, along with remedies, law also brings with it unintended mischiefs, unintended problems. I believe that although the law was enacted, the good provisions of this law have been fallen through the cracks beneath crack, because there are a lot of cracks in the law. And therefore, all the good provisions, whatever good provisions are there, those provisions, the rigor of those provisions are ineffective due to the cracks. Therefore, I would conclude by appealing to all of you that just don't read the provisions. Try and analyze those provisions. Try and understand the provisions in terms of their actual implications and impact on the lives of those for whom the particular law is enacted. So, thank you very much. Thank
Thank you, Dr. Sanjay Jain, for such an enlightening session. You have like clearly figured the whole picture, the whole scenario, how the disability laws, the disability provisions are being sandwiched in the like intoxication and other kind of provisions. Where it's like they should be given the privilege. It's like they should be given a place to be visible. So, on behalf of Pro Bono India and GNU Center for Disability Studies, I extend our heartfelt gratitude to Dr. Sanjay Jain for sharing his profound insights on this topic, the Rights of Persons with Disabilities Act 2016, particularly on duties and responsive public engagement mechanism. Dr. Jain's expertise, again, combined with his experience, has provided us with invaluable perspectives that will enhance our understanding and practice of disability law. In undoubtedly, your scholarly contributions, recognized even by Supreme Court, again, that I have made. I also thank all the participants for their active engagement and. Uh, Unfortunately, due to paucity of time, we are not having our Q&A session today, but it's undoubtedly it's a tremendous session, and your participation makes this capacity building program truly meaningful. So we look forward to seeing you all tomorrow for our next session. Until then, please reflect on the insights shared today and continue building your expertise in disability law. Thank you and good night.
Thank you.
Thank you very much, Sanjay sir, for
Yeah.
your great insights.
Thank you. Thank you.
See you, sir. Thank you very much.
Thank you, sir.